Yeah, you know what time it is. Disclaimer, I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice, and may you be blessed on your journey to find your power within these laws. Peace and blessings. All right. Now, let's take a look at the deed of trust. The deed of trust is the document that the banks need to have in place in order to take your property in the event that you default. How can they do this? Well, there's a simple strategy that they use, which is called foreclosure. Is where they use the trustee, which is the person that they have you give power to. They use him to take your home because you have him listed in the document giving him power of sale. All right, so let's go ahead and take a look at what a deed of trust is. I have it pulled up already right here. All right, this is Investopedia. What is the deed of trust? A deed of trust, also known as a trust deed, is a document sometimes used in financed real estate transactions, generally instead of a mortgage. Deeds of trust transfer the legal title of a property to a third person, such as a bank, escrow company, or a title company, to hold under until the borrower repays their debt to the lender. Although deeds of trust are less common than they once were, some 20 states still mandate the use of one when financing is involved in the purchase of real estate. States where trust deeds are common include Alaska, Arizona, California, Colorado, Idaho, Illinois, Mississippi, Missouri, Montana, North Carolina, Tennessee, Texas, Virginia, and West Virginia. A few states such as Kentucky, Maryland, and South Dakota allow the use of both trust deeds and mortgages. Okay. Key takeaways of this is a deed of trust is a document used in real estate transactions. It represents an agreement between the borrower and the lender to have the property held in trust by a neutral and independent third party until the loan is paid off. Deeds of trust are used as an alternative to a mortgage, but there are differences between these arrangements. A mortgage involves only two parties, the borrower and the lender. A deed of trust adds an additional party, a trustee, that holds the home's title until the loan is repaid. There are also different foreclosure arrangements related to these documents. All right, now how does the trustee work? We already know how it works. We just went over that. Let's go ahead and look at the difference between the two, the states that do have them and the states that don't have them. Deeds of trust can be compared with mortgages. Deeds of trust and mortgages are both used in bank and private loans for creating liens on real estate. That is, establishing a property as collateral for a loan. Key on that word, loan. Because of this, the contrary to popular usage, a mortgage is not technically a loan to buy a property. It's an agreement that pledges the property as collateral for the loan. A deed of trust is different from a mortgage in a couple of ways. First, a mortgage involves two parties, a borrower, who is the mortgagor, and the lender, the mortgagee. In contrast, a trust deed involves three parties, a borrower, or who they refer to as the trustor, a lender or beneficiary, and the trustee. Okay, so there's three components. It has to be the trustor, trustee, and beneficiary. Remember that. The trustee holds title to the property for the lender's benefit. If the borrower defaults, then the trustee will initiate and complete the foreclosure process at the lender's request. At the lender's request, Second, mortgages and trust deeds have different foreclosure processes. With a mortgage, the lender must pursue a judicial foreclosure. That is a court-supervised process enforced when the lender files a lawsuit against the borrower for defaulting on a mortgage. The process is time-consuming and expensive. In contrast, a deed of trust lets the lender commence a faster and less expensive non-judicial foreclosure by bypassing the court system and adhering to the procedures outlined in the trust deed. and state law. If the borrower does not make the loan current, then the property is put on for auction through a trustee sale. So the trustee has the power to sell our property in the event that we default, huh? Interesting. All right, we're gonna go now to deeds, U.S. legal law.com. Deed of trust. A deed of trust is a transfer of interest in land by a mortgagor/borrower to a mortgagee/lender to secure the payment of the borrowed debt. A deed of trust is an arrangement among three parties: the borrower, the lender, and an impartial trustee, which is an entity that holds bare or legal title. The borrower transfers legal title to real property to the trustee, who holds it as security for the loan. The borrower retains equitable title to and possession of the property. The trust deed is recorded with the county record where the property is located as evidence of and security for the debt. When the loan is fully paid, the monetary claim on the title is transferred to the borrower by reconveyance to release the debt obligation. If the borrower defaults in the payment of the debt, the trustee has right to sell the property and pay the lender the proceeds to satisfy the debt. The trustee will return surplus amount, if any, to the borrower. The right of the trustee to sell the premises is called foreclosure by power of sale. A foreclosure by power of sale is neither supervised nor confirmed by a court. The procedure for a foreclosure by power of sale is regulated by statute. All interested parties must be given notice of the sale, which must be published in the local newspaper, usually in the public notice column, for a certain period of time as required by statute. The sale is usually open to the public to ensure that the property will be sold at its fair market value. Trust deeds are the most common instrument used in the financing of real estate purchases in Alaska, Arizona, California, Colorado, Idaho, Illinois, Mississippi, Missouri, Montana, New Mexico, North Carolina, Texas, Virginia, and West Virginia. So, we have a pretty good understanding now what a deed of trust is. But let's look at some other things that they don't tell you about this document. Like, one, it's a contract, right? So, let's look at simple understanding what a contract is. And I have that pulled up right here. All right, we're at Cornell Law School. Contract. A contract is an agreement between parties creating mutual obligations that are enforced by law. The basic elements required for the agreement to be a legally enforceable contract are mutual consent, expressed by a valid offer and acceptance, importance, adequate consideration, capacity, and legality. In some states, elements of consideration can be satisfied by a valid substitute. Possible remedies for breach of contract include general damages, consequential damages, reliance damages, and specific performance. Now, let's just look at that. Let's key in on some key points of that what they just said what a contract is. All right, it has to be a mutual obligation. So if it's mutual, that means both parties are obligated or have obligations in this contract to do something. Whatever it is that obligation is, that's called performance. Okay? And it says the basic elements required for the agreement to be legally enforceable contract are mutual consent, so we both have to consent, expressed by a valid offer and acceptance. Offer and acceptance. We're going to touch back up on that. But now we understand that a contract has to be between parties with mutual obligations that also can provide an offer and acceptance, which is consideration. They got to have the capacity to contract, and the contract has to be legal. All right, let's continue. Now, I would like to focus on something. You see how this is got a hyperlink? Let's click that and see where it takes us. Offer and acceptance. It takes us to Uniform Commercial Code 2-206. Offer and acceptance in formation of a contract. Let's check out and see what this says. Okay, right here. Unless otherwise unambiguously indicated by the language or circumstances, an offer to make a contract shall be construed as inviting acceptance in any manner and by any medium reasonable in the circumstances. B. An offer or other offer to buy goods for prompt or current shipment shall be construed as inviting acceptance either by a prompt promise to ship or by the prompt or current shipment of conforming or non-conforming goods. But such a shipment of non-conforming goods does not constitute an acceptance if the seller seasonably notifies the buyer that the shipment is offered only as an accommodation to the buyer. Okay. 2. Where the beginning of a requested performance is a reasonable mode of acceptance, an offeror who is not notified of acceptance within a reasonable amount of time may treat the offer as having lapsed before acceptance. So an offeror who makes an offer to someone else to contract may treat that offer as lapsed if they don't receive notice of that acceptance. Let's keep that in mind. Now, let's look right here where it says firm offers. Let's key in a little bit more. Firm offers. An offer by a merchant to buy or sell goods. I do strongly advise to look up these definitions in your own terms so you can really get understanding what they mean when they say goods. In signed writing, which by its terms gives assurance that it will be held open, is not revocable for lack of consideration during the time stated, or if no time is stated, for a reasonable amount of time. But in no event may such period of irrevocability exceed 3 months. So you give them an offer and it can be open for a considerable amount of time, but that amount of time must not exceed 3 months, which is 90 days. Interesting. But any such terms of assurance on a form supplied by the offeree must be separately signed by the offeror. Alrighty, so if we offer to make contract with somebody, we need to be notified of acceptance within 90 days. Pull out your documents. Have you been notified of acceptance within 90 days? So do you have a contract there, or do you have an offer? And that offer happens to be recorded in the county. What would you do about that? What can you do about that? I want to tap in. Let's discuss. Now, let's take a quick look at what these documents look like in real time. All right, we're gonna pull up a good old deed of trust. Okay, we have a typo. That's the one to deed. We want deed of trust. All right, now let's go. All right, we got a deed of trust right here. Boom. Let's view this document. right, deed of trust and assignment of rents. All right, and we're going to look on this document real quick. Let's look at some definitions and see what's going on. Okay, borrower, they say means is this company right here. Then that's their address. Borrower is trustor. They use the word trustor, which is the person that's actually created this document is the trustor. The trustor has all the power because the trustor is creating this document. What is this trustor creating this document for? The purpose of a business dealing. What is the business dealing? It's supposed to be a loan, right? From the lender. Who is the lender? This lender is another company right here. They say this lender, if you scan through here, the lender is the beneficiary. Okay, the lender is the beneficiary of this negotiation or this contractual agreement, right? All right, and there's the note, which is a promissory note, which someone, the borrower, has signed, which is a promise to pay. Why did they pay this note? How much was this note for? It says $227,500. Okay, so why did they pay this note? Huh? This is a contractual agreement. There had to be something mutually exchanged. Okay, what was exchanged? They say loan. Well, let's see what the definition of loan is. Loan means the debt evidenced by a note. Plus interest. Any repayment charges and late charges due under the note, and all sums due under the security agreement plus interest. Hold on, it didn't tell me what was loaned though. It just made reference to what was promised to pay. A promise to pay does not constitute a loan. What was loaned? Ask yourself that. Okay, well, since we don't know what loan is that disclosure in this document? Or it looks like they're being kind of evasive on what's really going on here. If I loan somebody, I want it to be clearly stated that I learned whoop-de-whoop such and such in this regard. Was it a check? Was it cash money? Was it gold? Was it sheep? What was the loan? Okay. All right. So we've identified the trustor. We identified the beneficiary. We have not identified what was loaned. So as we keep scrolling, all right, boom. Trustee. Who is the trustee? Someone named Jason Courage Wise, Esquire. That is an attorney. That's an attorney. So an attorney was a trustee in this contractual obligation. Okay, well that's the three people. Let's scroll down a little bit and let's look for signatures, right? Let's go straight to signatures to see who signed this contractual obligation. Well, I only see two, and these were the borrowers. And then I see, there's the notary. The notary can verify that the borrower was there. But can the notary verify that the other two parties were there that did not sign this document? Go check your documents. They got an offer recorded on file in the county records that does not constitute as a contract. So if there is no contract, how could a trustee enforce something that he never accepted? I'm gonna let you ponder on that for a little bit. Peace and blessings.